Sure. I'm Randy Barnett. I'm the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where I also direct the Georgetown Center for the Constitution. Right. Well, I mean, with all due respect to my friend Larry Lessig, who I think is brilliant and who I really admired the work he did in the intellectual property sphere, and I was on his side in that issue, I don't think his brief is an actual originalist argument. It purports to be one. But what originalism is a discussion of what the meaning of the words of the text are and how the meaning of the words don't change just because we want to update them and we don't like them, or even when they get in the way of what we want to do. And discussing generally sort of what the gestalt was back in the day and what corruption is. I mean, the word corruption doesn't appear in the Constitution, and it doesn't really help us much to decide what is in the Constitution. So it's kind of a faux originalist argument done by someone who is not himself an originalist. It's not unusual. In both the Second Amendment area and in the Commerce Clause areas, you have lots of legal historians who themselves object to originalism, and yet they sign amicus briefs trying to instruct the court on what the original understanding of this or that was. The irony here is that one of the objections they have to originalism is that it's too complicated and you really can't do it. And then they turn around and purport to do it themselves when they sign amicus briefs telling the court in their expert opinion what the original understanding was. But most of them don't really understand how to practice originalism, and therefore their briefs typically miss the mark. They're really not about what an originalist justice or judge ought to be looking at. I actually have an article coming out in the Fordham Law Review on this very subject called The Gravitational Force of Originalism, in which I argue that originalism plays obvious roles sometimes, but less obvious behind-the-scene roles other times. And one of the first things you have to realize to understand why originalism doesn't play into most cases is that originalism is a theory of interpretation. It's a theory about what the words of the text mean. And most of what the court does, 99% of the time, is interpret its own doctrine. And what legal doctrine is a way of putting what the text says into effect. And it is what originalists or constitutional law theorists now call constitutional construction, as opposed to constitutional interpretation. So most of what the courts are doing is interpreting their own past precedents. They're not interpreting the meaning of the text itself. And so that's the reason why originalism rarely plays a role. Where the courts are operating with very limited precedent, as they did in the Heller case, then you see that both sides of the court are very concerned about what the original meaning of the text is. In the Affordable Care Act challenge, one of the reasons why we actually didn't make an originalist argument at all in that case, but one of the reasons why we had some room to move is because we argued, I think successfully, that this particular law, the individual insurance mandate, was unprecedented. Literally, it had never been done before, and therefore past precedent didn't really apply. So originalism can apply directly if the court is dealing with the words of the text. In the McDonald case, interesting that you would raise the McDonald case, because the McDonald case dealt with there was a lot of precedent that got in the way of the original meaning of the text. Nevertheless, the fifth and deciding vote by Justice Thomas was an expressly originalist vote, and he did not join the plurality opinion by Justice Alito, which was not as originalist. It didn't follow the original meaning. But even Justice Alito's plurality opinion in McDonald did not contradict the original meaning and tried to stay true to it while it was following precedent. And finally, I would say in the Affordable Care Act challenge itself, even though we made no originalist arguments, and I made no originalist arguments except in an article in which I point out that this really did violate the original meaning of the Constitution. I think originalism is operating in the background because it explains in part the Rehnquist Court's New Federalism, which basically said that it was going to accept the precedents of the New Deal, and so Congress could go this far, but if it was going to go any farther than that, then it was going to have to offer a special justification, and that justification would not be one that could lead to an unlimited police power in the state. So there had to be a limiting principle on any argument that went farther than where it's previously gone. Now, why would they hold Congress to go this far and no farther? And the answer is that going this far really stretches way beyond the original meaning of the Constitution, and so is somewhat illegitimate. It's going to be okay on the basis of precedent, but it's somewhat illegitimate on originalist grounds, and therefore, if you want to go any farther, you better have special justification that doesn't undermine the whole scheme that's identified by the original meaning of the Constitution. So even in a case where we make no originalist arguments, the doctrine that's being employed by at least 5 justices is influenced by the gravitational force, shall we say, of originalism in the background. Well, I have to tell you that the relationship of precedent to original meaning is controversial amongst scholars who consider themselves to be originalists. So I'm on one side of this issue and other people are on the other side. My own view is that precedent should not be allowed to trump the original meaning of the text, and typically doesn't. But it has in the past, and it should not be allowed to. So any precedent that's inconsistent with the original meaning of the text ought to be reconsidered. But the other point I was making earlier is that most precedent is not about interpretation at all. It's about putting into effect what the text says. So for example, the text protects the freedom of speech. It doesn't say anything about what the reasonable regulation of speech would look like. So we have a very elaborate doctrine governing the time, place, and manner, for example, of when you can assemble and when you can speak and how you can speak, so as not to interfere with the liberties of your fellow citizens who are, at the time you're trying to block the road or just trying to get to work. All of this time, place, and manner doctrine is not in the Constitution. It's not a matter of original meaning, so therefore, and it's a matter of constitutional construction that tries to effectuate what is in the Constitution, the freedom of speech. And when the court is dealing with their own doctrine, precedent plays a very important role in developing that doctrine and causing that, and helping them to be consistent, and particularly to give guidance to lower courts who are deciding how to follow the instructions of the Supreme Court. So most of the time, precedent is fine. It's just where it goes against original meaning is where I think it ought to be reversed, and where other originalists think, well, maybe with the passage of time and the basis of reliance, that maybe the precedent can still go on, even if, as I said in the context of the Rehnquist Court's New Federalism, because it violates original meaning, you can't go farther. And mainly what the other side, what the non-originalist side, or what the left or the progressives basically are saying is, look, we just want to extrapolate a logical line from where we are to where we want to be. And so, once you've established this precedent, then you can just go all the way. And that's really what the Rehnquist Court rejected. They basically viewed the New Deal as a high watermark rather than a principle that could be extended indefinitely. And if you want to go above that high water mark, you better have a justification that does not undermine the whole system. There was a view on the part of professors who never agreed with the Lopez and Morrison decisions and never agreed with the Rehnquist Court New Federalism, that the Rehnquist Court New Federalism had fizzled out and failed and had been abandoned, and we couldn't be 100% sure they were wrong about that. After all, in the Raich case, which is taken as evidence of the fact that the Rehnquist New Federalism had been run its course, you had Justice Kennedy and Justice Scalia go over and uphold the application of the Controlled Substance Act to my client, Angel Raich. And then you had, of the 3 dissenters, Chief Justice Rehnquist was no longer on the court, Justice O'Connor is no longer on the court, leaving only Justice Thomas. And so it might look to an observer as though this was an 8-to-1 situation at best, because the Rehnquist Court New Federalism was over. I always thought this was a misreading of Raich. And a misreading of Justice Kennedy and Scalia's views. And then I was only concerned with Chief Justice Roberts and Alito's views, because we really didn't know what they were. We hadn't really heard from them about this very much when they were lower court judges. But as it turns out, what the case reveals is that there are still 5 votes for the Rehnquist Court's approach. It's now the Roberts Court's approach with respect to the Commerce Clause and the Necessary and Proper Clause, and we actually clarified and made better law on the Necessary and Proper Clause than we've ever had before. The way the case came out badly, and the reason why the Affordable Care Act was largely but not completely upheld, is because of the constitutional problem that the majority saw with the individual mandate as a mandate. Chief Justice Roberts decided that he could revise that, make it not a mandate at all, but make it an option to purchase health insurance or pay a modest tax, provided the tax remained modest. And under this, what he called a saving construction, which is a change in the text from its natural meaning, he could then uphold the rest of the law, having made that change. So in a sense, we objected to the law as written, which is really all you can object to, and he upheld a different law than the one that Congress enacted, and that itself poses certain, I think, separation of powers problems. Yeah, well, I mean, the separation of powers argument is simply that Congress passed the law it passed, and the court is upholding a different law than Congress passed, so that the law that got upheld is never one that was voted on by Congress. So that's the separation of powers argument. I think the issue is whether you like the Constitution or you don't. I happen to like the Constitution as amended. And therefore, I would like to see it enforced, all of it, including the parts that conservatives don't want to see enforced, like the Ninth Amendment I mentioned above, the Privileges or Immunities Clause, which says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That was at issue in the McDonald case. That's a part of the Constitution that was part of the 14th Amendment, was considered to be central to it, and yet it has disappeared because of the Supreme Court's misinterpretation of that, and now it's sticking with its precedent. So to the extent I advocate anything as a constitutional lawyer or as a law professor, I advocate for sticking with the Constitution, the whole Constitution, even the parts that get in the way of what you might want to do, because in fact the other parts you might value, and we should really we should either follow the whole Constitution or we should change it. And I think part of the reason why, and this is not a thought that's unique to me, part of the reason why it doesn't get changed as much as it used to is because if the Supreme Court is going to do all the changing, it's an easier way to do it than actually having to muster the political will to change it through the amendment process.